The motion was withdrawn after a motion to revoke was filed and the case was dismissed. Then you had a theft case in 1995. You were granted 6 months probation. A motion to revoke was filed, then withdrawn. Case was closed. In 1996, you had a driving while intoxicated case. You were given 6 months probation. A motion to revoke was filed. Probation was revoked. You were sentenced to 30 days in the Bexar County Jail.
As the judge delivers her decision.
Court is calling 2024 CR 5072. Counsel, you're on this side. State of Texas versus David Michael Lynn. Could I have?
This isn't just another theft charge. David Michael Lynn's history stretches back to the mid-90s, packed with probation violations and jail terms. But watch closely. The judge asks one brutal question that slices to the heart of it all.
The document entitled Application for Community Supervision with your attorney. Did you understand it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we waive the reading of the indictment.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Lynn, did you review the document entitled Court Admonishments and with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of theft under $2,500 enhanced? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand? I'm sorry, just one moment. Okay. Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he was.
Mr. Lynn, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a cap of 14 months in the state jail facility. The state opposes your application for community supervision and deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That's our plea.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No motions.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence.
Contained in Exhibit 1 and any attachments, Your Honor.
No objection.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments, and the court will review the same. All right, after reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Counsel, do you wish to proceed with sentencing?
Your Honor, we have applied for deferred and probation. The state opposes.
All right, so, okay.
And it's a cap of 14. If you still want to waive or go to PSI.
No, we'll do the PSI
Yeah.
probation. They're saying the PSI is August 22nd. Is that the earliest we can do?
Unless it's a rush.
All right, can we do a rush? All right, what would be,
Here's the turning point. Lynn pleads guilty, and the prosecution locks in evidence with no live testimony. It's a quiet but devastating moment. Ever wonder why cases like this feel so one-sided? The weight of his past looms large.
Few minutes.
Okay.
Now we can July 25th.
all right, we'll come back on July 25th.
Here.
And probation, that'll be a PSI and TAP evaluation. All right, Ms. Ferguson will give you a reset form. After he speaks with probation and signs the reset form, he'll be excused. All right, the court is calling 2024 CR 5072, State of Texas versus David Michael Lynn. Can I have parties announced for the record for the state?
Andrew Harris Sadelman.
Defense?
James Seeloff.
And are you Mr. Lynn?
Yes, ma'am.
All right, you entered a plea of guilty on June 27th. And according to the plea bargaining agreement, punishers is to be assessed at a cap of 14 months in the state jail facility. The state opposes your application. Have both parties had a chance to review the PSI report, state?
There you are.
Defense?
Yes, I have.
All right, any objections?
No objections.
All right.
Although he does say that he can live with his parents as opposed to being homeless.
Okay.
Is that correct?
Yes.
All right, so the state is opposed to your application. Any witnesses, defense?
No, Your Honor.
State, do you have any witnesses?
No, Your Honor.
All right, the court will hear argument.
Your Honor, my client has never been on felony probation, and he's never had the theft course. And I asked the court to take a look at the offense itself and what was stolen. He was homeless at the time, and currently he says that he can live with his parents. And I asked the court respectfully to consider probation.
All right.
In
And
this circumstance, do you have anything, David?
Well, yeah.
just 1 second. Counsel, could you have another trial court certification filled out for me, please?
Another one?
Yes.
Okay.
It is on the box. Because this one is dated June 27th, and I think it's because the court thought that we were proceeding with sentencing at that time. And then after you sign that, the court will hear testimony from you, Mr. Lynn.
All right.
This document says is that this is a plea bargain case and you have no right to appeal if she follows the plea bargain. Okay? Which is not one of them. Need your signature there. Here you go, Your Honor.
Counsel. All right, Mr. Lynn, if you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
David Lynn.
All right, counsel, would you wish for your client just to talk to the court, or do you have questions?
No, I would like my client to address the court.
Yeah, I'm just living in my parents' house. I'll be taking care of them. My mom has dementia and my dad can barely walk. So I'm kind of like their caretaker.
All right, when people are on probation in this court, I don't allow them to be home health care providers.
Well, no, I'm not getting paid for it. I go over there and help them out.
Okay.
Yes.
Why were you not doing this before you picked up these new cases?
I've been going over there.
Mhm.
Yes, ma'am.
All right, so here's the court's concern. Looking at your criminal history, you have a criminal trespass. You were placed on deferred adjudication.
Notice the defense leaning on compassion. Lynn as caretaker for parents with health issues. But the judge pushes back. Can hardship excuse decades of theft? If you were on the jury, would mercy or history guide your decision?
Case was closed. In 1996, you had a driving while intoxicated case. You were given 6 months probation. A motion to revoke was filed. Probation was revoked. You were sentenced to 30 days in the Bexar County Jail. Then in 1997, you had assault, bodily injury, married. You were given deferred adjudication. A motion to adjudicate guilt was filed. You were revoked, sentenced to 6 months. In 1997, you had a driving while license suspended. Your probation was revoked. You were sentenced to 52 days in the Bexar County Jail. And then also in 1997, you had another driving while license suspended, 6 months in the Bexar County Jail. November 1997, driving while license suspended, 6 months in the Bexar County Jail. July 1999, driving while license invalid, enhanced. You were given probation for a year. Motion to revoke was filed. You were sentenced to 6 months in the Bexar County Jail. 2003, you had a theft, $5,500. You were sentenced to 90 days in the Bexar County Jail. 2006, you had a driving while license invalid. You were sentenced to 30 days in the Bexar County Jail. 2006, you had a theft, $50 to $500. You were sentenced to 45 days in the Bexar County Jail. 2006, you had a driving while license invalid, enhanced. You were sentenced to 30 days in the Bexar County Jail. 2007, you have a driving while license invalid. You were sentenced to 30 days in the Bexar County Jail. 2007, you had a criminal trespass to habitation or shelter. You were sentenced to 75 days in the Bexar County Jail. 2023, you had a criminal trespass to private property. You were sentenced to 26 days in the Bexar County Jail. 2007, you had a theft under $1,500 enhanced. You were sentenced to 6 months in the state jail facility. 2008, you had a theft under $1,500 enhanced. And a motion to revoke was filed, and you were continued on probation. And then you were revoked and sentenced to 6 months in the state jail facility. 2010, you had a theft, $1,500 enhanced. You were sentenced to 8 months in the state jail facility. 2012, you had a theft under $1,500 enhanced. You were sentenced to 10 months in the state jail facility. 2013, you had a theft under $1,500 enhanced. You were sentenced to 12 months in the state jail facility. 2013, you had a theft under $1,500 enhanced. That was dismissed. You were convicted of another offense instead of that. 2014, you had a theft under $1,500 enhanced. You were sentenced to 4 months in the state jail facility and given a judgment satisfied under 1244. 2015, you had a theft under $1,500 enhanced. You were sentenced to 12 months in the state jail facility. August 2015, you had a theft under $1,500 enhanced. That was dismissed. You were convicted of another offense. 2023, you had a theft under $2,500 enhanced. You were convicted of another offense. And then now we have your current offense. Then out of county in Guadalupe County, you have a theft of property. You were sentenced to 60 days. You had a driving while license invalid. You were sentenced to 127 days in New Braunfels. Then in 2007, you had a reckless driving. You were sentenced to 20 days. Then in Travis County, you had a theft, $1,500, 2 or more previous convictions, and you were sentenced to 6 months in the state jail facility. So the question becomes, why do you not stop stealing?
Because I had a gambling problem.
All right. Is there anything else?
So,
All right. The court is going to find you guilty. The court will deny your application. The court will sentence you to 14 months in the state jail facility, give you credit for any time served.
Thank you, Your Honor.
Thank you. Did you review the document entitled
Ma'am,
Certification of Defendant's
Ma'am,
Rights to
we're-
Appeal with your attorney? Did you understand it?
When me and him were not,
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal.
In the end, the judge denied probation, sentencing Lynn to 14 months in state jail. His gambling excuse wasn't enough to outweigh years of repeat offenses. What's your take on this ruling? Drop a comment, hit like, and subscribe for more dramatic courtroom moments.